On April 3, 2015, Anthony Ray Hinton walked out of an Alabama jail. The last time he had been free, Ronald Reagan was president. Mobile phones were expensive bricks. The modern internet barely existed. Hinton had spent almost 30 years on death row. For most of that time, the state insisted it had convicted the right man. It had a murder case, expert testimony, a death sentence, and legal permission to kill him. Then, the case collapsed. Hinton walked outside, hugged his family, and began a life that had nearly ended inside an execution chamber. The state could release him only because he was still alive. His case exposes the obvious danger of getting a death sentence wrong, but it does not settle the whole argument. 2 restaurant managers had been murdered. Their deaths were real. Their families still lost them. And Hinton's innocence does not tell us what should happen to a murderer whose guilt is beyond serious dispute. So imagine that person instead. They are caught, convicted, locked inside a prison they will never leave. The public is protected. They will die behind bars. What does execution still add? The most practical answer is safety. A dead offender cannot escape. They cannot be paroled, pardoned, or released after a future change in the law. They cannot attack another prisoner or a member of staff. Lawyers call this incapacitation. In normal language, it means removing someone's ability to cause more harm. Execution does that completely. No escape, no release, no second victim. But life without parole already removes that person from the public. It does not eliminate every possible risk. Violence can still happen inside prison. Laws can change, governments can grant pardons. Still, the main job is already being done. The convicted murderer is separated from ordinary society and is supposed to remain there until death. Execution does not create the separation. It makes the separation impossible to reverse. That sounds like an advantage, until the legal system changes its mind. In Hinton's case, finality would not have protected the public from a dangerous murderer. It would have protected a wrongful conviction from ever being corrected. So public safety explains why a murderer may need to lose their freedom forever. It does not fully explain why they must lose their life. Maybe execution is not mainly for the prisoner. Maybe it is for everyone watching. This is deterrence. Make the punishment frightening enough, and another person may decide not to commit the crime. The logic is powerful. One person is executed. Several future murders never happen. Innocent lives are saved. But the question is often stated incorrectly. The question is not whether murder should carry a severe punishment. Almost everyone in this debate agrees that it should. The question is whether execution stops someone who would not be stopped by the prospect of spending every remaining year inside prison. For that difference to matter, a potential murderer must know the punishments. They must believe they will be caught. They must believe they will be convicted. Then, they must prefer lifelong imprisonment to execution strongly enough to abandon the crime. That may describe some planned murders. It does not neatly describe a killing committed during rage, panic, intoxication, or severe mental disturbance. It also does not describe an offender who assumes they will never be identified. A warning can be terrifying and still fail if the person never expects to face it. Researchers have spent decades trying to measure the effect. Some studies claimed executions reduced murder. Others found no clear effect. Some suggested the opposite. A major review by the National Research Council concluded that the available research could not reliably determine whether capital punishment decreases homicide, increases it, or makes no measurable difference. That does not prove execution never deters anyone. It means the evidence has not proved that execution deters murder better than permanent imprisonment. The warning might work. We cannot honestly say the research has established it. Now go back to Alabama. In 1985, 2 fast food restaurant managers were killed during separate robberies. There were no eyewitnesses to those murders and no fingerprints identifying Hinton. Then a 3rd restaurant manager survived a similar shooting and identified him from photographs. Police searched Hinton's mother's home and found an old revolver. State examiners said that gun had fired the bullets in all 3 crimes. That alleged match became the center of the case. Hinton's court-appointed lawyer knew he needed a firearms expert, but the lawyer mistakenly believed he had very little money available. He eventually hired a civil engineer who lacked meaningful firearms identification experience and could not properly operate the equipment needed to examine the evidence. The prosecution presented its experts. Hinton's defense could not answer them convincingly. He was convicted and sentenced to death. No secret conspiracy was required. An old gun, disputed forensic evidence, inadequate legal help. That was enough. Years later, 3 respected firearms examiners reviewed the evidence. They said the bullets could not be matched to the revolver, and Hinton still remained on death row for more than another decade. In 2014, the United States Supreme Court ruled that his trial lawyer's performance had been constitutionally deficient. Alabama's own forensic scientists later confirmed that the bullets could not be linked to the gun. Prosecutors dismissed the case. After nearly 30 years, the evidence that had placed Hinton near execution could no longer keep him inside a jail. Hinton's case would be easier to dismiss if it were a bizarre exception. It is not. Since 1973, more than 200 people sentenced to death in the United States have later been exonerated. These cases did not all fail for the same reason. Some involved false testimony. Others involved mistaken identification, official misconduct, inadequate defense work, or forensic evidence that did not survive later examination. But every case reached the same dangerous stage. A court had authorized death before the conviction fell apart. Now remember the first argument. Execution was attractive because it was permanent. No escape, no release, no second chance. Permanence does not check whether the decision is correct. It simply freezes the decision the system made. When the conviction is sound, that finality falls on a guilty person. When the conviction is wrong, it falls on someone like Hinton. The death penalty's strongest practical advantage becomes its strongest practical objection. Appeals, retrials, and new evidence are supposed to protect against mistakes. Hinton's freedom shows that those protections can eventually work. His 30 lost years show how slowly. Prison was not reversible in any meaningful human sense. Nobody could give him back his youth, his family time, or the decades he spent waiting to die. But one correction remained possible. The door could open. Execution removes even that. A later judge may identify the error. A witness may confess to lying. New testing may destroy the original evidence. So where are we? Execution permanently removes a threat, but prison can already remove that person from the public. Execution may deter some crimes, but the evidence has not shown that it creates an additional deterrent beyond severe imprisonment. And the promise of finality becomes dangerous when the legal system makes a mistake. Yet the argument for execution survives, because its deepest justification was never mainly about what the offender might do next. It is about what the offender deserves for what they have already done. A life sentence can protect society. It can punish someone until death. It can condemn the crime in the strongest possible terms. What it cannot do is take the offender's life in return. That argument is called retribution. The word can sound like a respectable version of revenge, but supporters draw a distinction. Revenge is personal, emotional, and uncontrolled. Retribution is supposed to be measured by law, evidence, and proportionality. The offender is not executed because the prison walls are too weak. The offender is executed because the crime is believed to deserve death. For supporters, a person deliberately destroyed an innocent life. Anything less than execution leaves the moral account unpaid. For opponents, the victim cannot be restored. A second death does not repair the first. They argue that the state proves its commitment to human life by refusing to kill, even when dealing with someone who did. Both sides begin with the seriousness of murder. They separate over one question. Does justice require the government to repeat its finality? So what does execution accomplish that permanent imprisonment cannot? It does not merely keep a murderer away from society. A locked cell can do that. It has not been shown to provide an additional deterrent that permanent imprisonment cannot. And condemnation does not require an execution. A person can be imprisoned until death. Execution does one unique thing. It makes death part of the punishment. The death penalty ultimately depends on the belief that, for certain crimes, taking away every remaining year of freedom is still not enough. The offender must also lose every remaining year of life. Anthony Ray Hinton's case does not tell us what punishment every guilty murderer deserves. It tells us something about the institution making that decision. Alabama had a conviction, expert testimony, a death sentence. years of failed appeals. Then, the central evidence stopped holding together. The system changed its answer just before its first answer became permanent. And that is the choice beneath the entire death penalty debate. It is not only whether some murderers deserve to die, it is whether a government, run by fallible people, should possess a punishment that remains irreversible, even when the evidence, the experts, and the certainty